May it please the Lordship. My Lord, I beg to mention item number 9, my Lord, on behalf of the state respondents, my Lord. Mr. S. Sen, my Lord, he is a leading counsel, my Lord, here in this matter. He is on sanction leave.
Item
9.
9.
Item 9.
Yes. Are you ready? Are you ready?
You are for
No objection.
respondent?
For petitioner, Your Lordship.
Or you are for respondent?
My Lord, I'm for the respondent state.
On pre-made by the respondent? Pre-made by the state respondent? Not objected to by petitioner, matter is adjourned. This system after 2 weeks.
Much obliged, Lordship.
Excuse me.
Please, Lordship. Lordship, I pray that matter, item number 10 may be adjourned for a day, Lordship. Lordship, this matter also conducted counsel is Mr. S. Sen, Lordship. He is on sanction leave.
Oh, yeah, the petitioner here. This matter has not been heard.
No.
Prayer is made on behalf of the learned additional senior GA, Mr. S. N, who is said to be indisposed. Prayer is made seeking adjournment. No? The same not being objected to by the respondent. Prayer allowed. This is matter after 2 weeks.
Highly obliged.
Please, Lordship. Lordship, in item number 12, Lordship, I pray that this matter may come up after 2 weeks. Or 1 week, Lordship. Item 12.
On pre-made by the appellant. Matter is adjourned. This is same after 3 weeks.
From supplementary course list, item number 1.
Wait, please, Your Lordship. Wait, please, Lordship. My Lord, this is an application for grant of anticipatory bail. My Lord, in this case, what has happened, my Lord, on the 8th of April, my Lord, an FIR was lodged by the brother of the deceased, alleging that, my Lord, the applicant herein, along with others, assaulted his brother, and then he succumbed to his injuries the next day. Now, the real facts of this case is that, my Lord, this person, the deceased person, my Lord, is a habitual offender. My Lord, he was accused of theft in a particular market on that particular day. Now, my Lord, a mob thought of taking him to the police station before the authorities, and the authorities could have taken him to the hospital, my lord. The reason why he was taken to the police station, I say, is because, my lord, he was not injured to that extent. Had he been injured to that extent that he would succumb to his injuries, my lord, even if I had assaulted him, my lord, I would have taken him to the hospital. It's very logical, my lord. That is why, my lord, today I am only praying for some interim protection, my lord. Once the CD is produced before lordship will see.
Look into the CD. When can you produce the CD?
Today is
7.
let it come on 14, your lordship.
15, sir. 14 will be out.
15.
14?
15.
On 16?
Let be on
16?
lordship. 15, 16 also is fine, your lordship.
Alright, Mr. K.C.S. Godam, Learned Counsel for the petitioner, who has submitted that this application under section 438 CRPC is filed with a prayer for grant of pre-arrest bail to the applicant herein. Without going to the merits of the matter, at this point of time, the learned counsel has submitted that the case diary of, what is the case number?
Lydia Ganj Police Station.
Ganj Police PS case number 4 under bracket 4 of 2024 under section 302/34 IPC may be called for. So as to ascertain the involvement of the applicant. In the meantime, it is prayed that the applicant may be allowed to be enlarged on interim bail with any condition deemed fit to be imposed. This is the second bail application.
Second,
Yes,
yes, first was rejected by the.
Mr. Indishulai Leonard AAG, appearing for the state respondent, has strongly opposed the prayer made for grant of interim bail on the ground that in the earlier bail application filed by the petitioner, by the applicant, the Leonard Trial Court had rejected the same on the ground that the CD would reveal the involvement of the applicant as far as the assault on the deceased victim is concerned. Accordingly, considering the gravity and serious nature of the matter, though there is no objection for the production of the case diary, however, as far as interim bail is concerned, the Leonard AAG has submitted that the same may not be granted. This court has considered the submission made and has also perused the relevant order passed by the Leonard Sessions Court, wherein the bail, there was also pre-arrest bail,
Lordship, yes.
Pre-arrest bail.
wherein the pre-arrest bail was not granted to the applicant herein for the grounds stated therein, for the reasons stated therein. However, this court is also of the considered view that the case diary is to be produced to understand the impact and import of the offence alleged against the applicant herein and his complicity in the same. Accordingly, the state, accordingly, the prosecution is directed to produce the copy of the case diary with the latest status report on the next date fix. In the meantime, the petitioner is allowed to go on interim bail on condition that he shall not abscond or tamper with the witnesses and evidence, and that he shall appear before the IO as and when necessary. This is matter on 16.
Apply, Your Lordship.
Much obliged.
Item number 2.
Your Lordships, we have filed these transfer petitions to transfer the case from the district councils to any other court, Your Lordships. The purpose of filing this transfer application, Your Lordship, is that in the year 1990, a title suit was filed before the district council court in respect of land known as Law Langmatila and Law Pedang Tangle, if I correctly pronounce it, Your Lordship, which was registered as title suit number 3 of 1990.
Yes.
Subsequently, Your Lordships, the party has entered into a compromise, and on the basis of compromise agreement, the Honorable Trial Court has passed a decree, by degree judgment and degree dated 18/4/2012. Now the aggrieved persons, the persons who has aggrieved by the judgment passed on the compromise, Your Lordship, has filed a miss case in the year 2021, which was registered as miss case 38/50 of 2021. Now the same has been rejected by the Honorable Trial Court on the ground of delay and laches on by the order dated 7 June 2022, Your Lordship. Now both the order is under challenge. Now the problem here is, Your Lordships, on the judgment which was passed on the compromise, on the basis of compromise, was on 18/4/2012. At that time, the presiding officer she has been elevated as a judge of the district council, and the order passed by another presiding officer is on 7 June 2022 has been elevated as an additional judge of the district council court. So this matter cannot be tried by because both the judgment is under challenge, same cannot be tried by the district court. Honorable.
That is in Shillong.
That is in Shillong. So,
This case emanated from which area, which jurisdiction?
it's East Khasils, Your
East
Lordship.
Khasils.
Yes, Your Lordship.
It's council.
Yes, Your Lordship.
So it can be transferred to
Any
any of the districts.
If it can be transferred to the normal court, Your Lordships, then
Normal court, I see that more often than not, we would not resort to such, because that would be, conveying jurisdiction. What would be more proper is to transfer this case to another district council court, perhaps in, I don't know whether in Noppo they may have one. Not Joy. Even you see, now we have Noppo, we have Mokorot, we have Noxton. Oh, appeal.
now it's in appeal.
Oh, it should be before the judge.
Before the judge.
We have to take steps. Who's the respondent here? Who? Then you have to take steps. You have to be heard.
Your Lordship. But the prima facie also, Your Lordships, that it cannot be taken up by the district council court. Your
True,
Lordship.
that is true. But you also have to, you see, all the parties have to be present. They have to agree,
Your Lordship.
which in all probability they will not object, because like you rightly said, it cannot be taken up by either of the the two judges. They have to be. You take steps. You for the applicant. What, Mr. The counsel for the applicant, who has submitted that this is an application for transfer of the case. What is the case number?
Item number is the MCA number 1 of 2023.
No, we're talking about this Miss Civil Appeal number 8. This is item?
Item number 3. Yeah. 3 and 4 are connected matter.
Yes, so we're talking about item number 3.
3, yes, Your Lordship.
This is similar matter.
Similar.
Going to all? Transfer of Miss Civil Appeal 8 of 2022 from the court of the Leonard Judge District Council Court Shillong on the ground that the Leonard Court is disabled to take up this matter. Upon hearing the Leonard Council, this court on perusal of the records hereby directs the petitioner, the applicant, to take steps for issue of notice upon respondent. The notice returnable by within 2 weeks. List the matter thereafter. Two weeks.
Highly obliged.
Item number 5.
So 3 and 4 same order.
Same order, Malord, it's just the case number.
Only the case number. Took a 4 change the case number. Yes.
My lord, your lordship was pleased to call for the court and call details. This is
Yes, Dr. Muzika.
All details I couldn't find, my lord. I've received the charge sheet that was filed, my lord. And in fact, they have also annexed the charge sheet along with the petition
Yes,
itself.
but there is no detail. You see, details of this CDR. What this court would like to confirm,
My lord.
is whether the applicant was or is in contact with the main accused. Otherwise, what could be established is, if we accept his version, is that the accused here is just a mere driver of a public vehicle who was contracted to ferry some passengers. The passengers may be involved, may not be involved, we don't know.
Well, that I may not be correct, my lord. I'll just point out few lines from the charge sheet, my lord. Your lordship kindly comes to page 37, my lord, of the petition. But para 2. So for firstly, my lord, it was on the basis of a source information.
Yes.
That on 23/5/23 at 11 p.m. telephonically information received that cannabis ganja deal, storage and transportation would occur at Voirimbong, River District, Meghalaya by unidentified persons on a Maruti Alto vehicle bearing registration number so and so. The information was reduced into writing by Sri so and so, so that we can skip, my lord. So my lord, there is a source information indicating the vehicle number also, my lord.
Yes.
Now, my lord, para 3 lords will see.
Yes.
That based on said information, the officers of Customs Preventive Headquarters Shillong divided themselves into 3 groups, while the seizing officer Sri Andranil Chaliha accompanied the informer in the informer's private vehicle. The other officers divided themselves into 2 groups, led by 2 superintendents, that's Sri Asa M. Wajri and Sri Kenneth Walang, in 2 vehicles, ML05M 8522 official vehicle and another private vehicle. One of the team rushed to the areas and led surveillance on the Voirimbong Mao Lasnai road, with the other team followed the vehicle of the informer from far behind. The vehicle of the information in turn was following the Maruti Alto vehicle bearing registration number. But this is the offending vehicle, my lord. After reaching Liarbang village, the persons in the Alto vehicle showed the informer the place where the cannabis was kept. However, on seeing the vehicle of the custom officer from afar, the accused persons got scared and left the place in a hurry. While the Maruti Alto vehicle rushed towards Voirimbong, the vehicle of the informer followed them from behind. At around 3 a.m. of 24/5/23, the Maruti Alto vehicle was spotted by the group of officers in another private vehicle. On being signaled to stop, the driver of the vehicle defied the signal and sped away. So, my lord, kindly see the conduct, my lord. At 3 a.m. night, he tries to flee away, my lord. Then, my lord, the last subpara of the same paragraph. After a brief altercation with the custom officer, they agreed to take the officers to exact place where they had secreted the ganja. After reaching Liarbang village, independent witnesses were located, and the accused person led the officers of the witnesses to a forested area where 24 packets of compressed black blocks wrapped in brown tape suspected to be ganja were found.
So section 27 of the Evidence Act was complied with.
No.
My lord, sampling was done before magistrate, my lord. Lots of will see that at
27, not 52. Section 27.
section 20, please.
No, just point out where is the direct evidence of the complicity of the accused person. There were how many occupants of the vehicle? 4.
4, your lordship. 2 passengers were there. I was driving, and my brother was accompanied since it was night.
Para 30, lots will see.
Para?
Para 30, my lord. There's some call details also.
Page number.
Page 52, my lord. Para 30, lots.
This Shankar Saha is the main accused. What is his role?
Your lordship, they have presumed that he may be main accused. There is no material in the final complaint that he is involved.
He has not been arrested.
No, he has not been arrested. And there is no material also how he is involved. They are saying that since there is no CDR also, of course they have mentioned, but there is no CDR enclosed with the final complaint. But they are saying that since I was contact with Shankar Saha, there is no material that whether he is involved or not, that's why they have implicated me. And particularly regarding this para 30, there is no CDR available in the final complaint. They have not submitted.
That is why you see, Dr. Musa, that should have been there in the, because the CDR has to be there. In the CDR, you would find a list
Yes.
of the details of the call made.
They have not enclosed. They have not filed with the complaint.
Paragraph 32 is the, I think, that is the summation of the
Yes.
finding.
Yes. Based on this, they have said that we are involved based on the statement and all these things. But there is no concrete material enclosed with the final complaint. Whether Shankar Saha is also involved or not, they have not investigated into that aspect. And they have not collected any evidence materials. So on mere speculation, final complaint has been filed in hurriedly without properly investigating into the matter.
Right, page 53, my lord, sub para C of para 32, my lord, so can you see this?
Listen, I've read that.
As per statement of Sanjeev. Yes, my lord.
See, this Sanjeev Guha is also one of the arrested accused.
Occupant in the vehicle. He was arrested.
He was the one who has contracted you to
Take them
drive
to, yes.
take them there.
Yes.
What is your relationship with him?
No relationship.
How long have you known him?
No, I have not known to him any longer because there is no coordinator also. He has just booked my taxi and we have agreed. There is no contact detail also that I have been in contact with these two passengers also.
See, Dr. Mazika, the investigation first should reveal the relationship of these two accused,
Yes.
the driver and the co-driver, so to say, or the handyman, with those two other passengers who apparently may be involved. Now they have also named the mastermind, who is said to be that
Yes.
Shankar Saha. But what is their relationship? How long have they known these two
Yes.
person here?
My lord, what indicates, my lord, these two petitioners, my lord, they are in constant touch with the Saha, Shankar Saha, my lord. No, Shankar Saha has deputed this Sanjeev Guhai to execute the transaction, my lord. And this person, he also says that both of them were offered 10,000. My lord, at 3 o'clock night, otherwise no normal local taxis seen, my lord.
So you see, it is you see understandable that 10,000 may be offered to them.
Yes.
For what reason? You see, they may not know, they may know, they may suspect whatever thing, but they are
Agreed.
that is their job. The only thing is that you have to find a link between these two persons
With
and
us.
the mastermind or the perpetrator or whoever is involved.
Well, also grant me 1 day time, my lord. I was traveling also yesterday. My lord. I'll just call them
First,
if
you
there
have
is
to-
any other material, my lord.
Any other material, first to establish
The link.
the link between the accused person in question with those the other accused person. What is their relationship? How long have they known them?
My lord.
What is the connection? The CDR and those things will be established. Then, as far as the in paragraph 30, you have said that they have contacted the so-called mastermind.
Yes.
My lord.
So that is, as Mr. Pandit said, that is also, you see, remains to be seen whether he is really involved or not. It has not been established. What could be understood is these two persons who have been arrested, perhaps since the contraband was recovered at their instance, perhaps
Basically, lots of us examine they are just by chance simply
you see,
hired
you have to understand,
without their knowledge, or they had some.
That is why, that's the thing. You see, you cannot just punish a innocent person. A taxi driver, for that matter, he is plying his vehicle for his employment.
Well.
If he has no link at all, why would you rope me?
Well.
Pre-made by the Leonard DSGI, this is matter after 1 week.
After?
But final 1 week.
No, Lordship, final complaint has been filed and
Let him get. See, Mr. Pandit, you have to understand. We are dealing with
Yes, and
we are dealing with a matter under Section 37.
yes.
Until and unless the court is convinced
Satisfied,
that
yes.
you are not guilty,
Yes.
then.
Fine.
Otherwise, if there's, you see, prima facie is a very thin line.
Yes, your Lordship. Reasonable ground and
It's
prima facie
reasonable-
case is.
True.
Yes. No. Obliged.
Item number 7.
Yes.
Yes, Your Lordship, we have filed the written
Have you filed?
Yes, Your Lordship.
You've also filed?
My lord, I'm a former party here, my lord, so
Whoever is required to file their written argument, have you filed?
Yes. I'm for respondent 2 and 3, Your Lordship.
they are
Fine. Learned counsel for the petitioner, as well as the learned counsel for the respondent 2 and 3 have submitted that the written argument on behalf of the respective clients have been filed today. The other respondent, that is 1, 2 and 3. As far as the respondent 4 is concerned, as has been submitted, the written argument on his behalf. Who is the respondent for? His or her?
who is the complainant, my lord?
On his behalf is not required to be filed. Accordingly, the matter is now posted for judgment, reserved for judgment.
Much obliged.
Daily list item number 1.
Your Lordship, in this case, I came to know this SLP is going to be listed shortly, Your Lordship.
How long will we wait?
Already it has been rectified and everything is done. Now it will be come for hearing.
Rectified.
Rectified.
Earlier there was some.
There was some defect and it is rectified.
We'll wait. We see, Mr. Nupil, if the SLP is filed and some order is passed. If some order is passed, then if there is a conflict, then this court would have to bow down.
It can come after 3 weeks, Lordship.
Mr. Ardevna, the CGC has submitted that the SLP, which is supposed to be filed before the Honorable Supreme Court, has been filed, and the same would be taken up for hearing in due course. In the meantime, it is prayed that this matter may be adjourned for the time being. On prayer made, this is matter after 6 weeks. I think that'll give you enough time to.
Yes, item number 5 also will be remain same.
1 and 5, Lordship.
Same order.
Item number 2.
In terms of the last order, I have taken steps on respondent number 2, my lord. But I have not received any report yet, my lord, from the post office.
Mr. KCH Gautam, Land Counsel for the petitioner, has submitted that all those steps have been taken for issuance of notice upon the respondent number 2. No report has come so far. It is prayed that the matter may be, that the said report may be awaited. We are allowed, this is matter up to 2 weeks.
2 weeks.
My lord, in the meantime, we may be allowed to file our affidavit. We have not filed our counter in these cases.
And as far as the other respondents are concerned, the
1 and 3.
The counter affidavit on their behalf may be filed in the meantime.
Obliged.
Item number 3.
Your Lordship, in this case, I was not in a position to finalize my affidavit because some more instruction was required. Then I didn't get this instruction.
What about 3 and 4?
And on behalf of respondent,
Have you filed your counter?
we have filed an affidavit in opposition, Your Lordship, on September 29th.
Mr. R. Debnat and CGC appearing for respondent 1 and 2, respectively, has submitted that the counter affidavit is not yet ready, and as such, it is prayed that some more time may be allowed for the same to be filed. The prayer not being objected to by petitioner, same is allowed. Let the said counter affidavit be filed within the next date fix. This is matter of the 2 weeks.
3 weeks, Your Lordship.
3 weeks.
Item number 4.
One is not here. The managing committee is also a party, my lord.
Not the managing.
What is required here, Mr.
Here, Lordship, matter was heard quite long time. Then my friend, during the course of hearing,
That RTE
yes, Lordship,
tribunal and all those things.
my friend, in the midst of hearing, my friend has stated that as per the RTE rules, Rule 20, there is a provision for constitution of tribunal, Lordship. That since there is a tribunal, I should have approached to the tribunal.
That is the only issue to be decided.
On this instruction, Lordship, on this instruction, my lord, he has filed the affidavit that the order was reflected 23rd August 2023. So now my friend, he has filed the affidavit not with regard to the tribunal, Lordship. In fact, there is no tribunal. He said that applicability of the rule. So rule, so far as the applicability of the RTE rules, I said that this is applicable all.
That's a matter of argument.
My lord, two aspects. My lord, one aspect was that, my lord, because my friend had contended that the rules that will be applicable is the Meghalaya Education Act. My lord. We stated that since it is an SSA, the Education Act will not apply. It is the RTE rules which will be applicable. The RTE Act as well as the RTE rules. My lord, in the RTE rules as well as Act, there is a mechanism for grievance redressal, my lord. Yes, it is a fact that there is no tribunal. They ought to have been there. However, my lord, there is a certain mechanism which is in existence, which is being followed, my lord.
Apart from the tribunal.
Yes, my lord. In these sort of grievances. So that is what we brought on record by way of an affidavit. So my friend may continue, my lord.
Lordship, if my lord kindly refer to order 23rd August 2023, Lordship.
So are we clear on that?
Yes.
So then you have to refresh this court.
Yes,
as far
Lordship.
as
I'll
the
just
merits of the case is concerned.
Yes, Lordship. Yes, Lordship.
Let us see. Let the court hear the merits of the case.
Yes, Lordship.
In the meantime, whatever contention you
Yes,
have,
Lordship.
whatever
Yes,
point you have to raise, you do it. Otherwise, you take it piecemeal, and it becomes very difficult. All the parties are in.
Yes, Lordship. Yes, Lordship. Then I'll argue from my written submission, Lordship, because this is a compilation, Lordship. Because
you argue on the merits of the case, Mr. Your written argument, if you want to refer to, well,
yes,
good.
Yes, Lordship. Pardon, Lordship. Here, Lordship.
Yes.
The school was established in the year 2010, Lordship. 2000, Lordship. 2000.
First, you indicate the status of the petitioner.
Yes, Lord. I am coming to that, Lordship. 2000, Lordship. Then at the time of establishment, Lordship, there are 3 teachers who were appointed. This is the LP school. Then out of 3, Lordship, 1 teacher has already resigned. Because there is no sanction, because the lump sum is being paid by the management from the resources of the managing committee. Then in 2001, Lordship, the headmaster of the school retired, Lordship. Resigned. Then in his place, Lordship, the petitioner was appointed as the headmistress of the school, Lordship. Now 2001 till date, Lordship, she has been serving as the headmistress of the school. Now subsequent, Lordship, in the year 2001 to 2002, Lordship, the SSA came to be implemented in the state of Meghalaya, Lordship. I have given the notification with regard to the implementation of the SSA, Lordship. Then subsequently, Lordship, after 2002, Lordship, the school was brought under SSA. And lump sum salary were paid to the school, Lordship. Then in 2015, Lordship, 14 in fact, the private respondent put up an application before the state authorities saying that since I was joined prior to the petitioner, so I should be promoted to the post of headmistress and petitioner should be placed to the post of assistant teacher. Now this represent, based on the representation, Lordship, the authorities has directed for inquiry, Lordship. It has been inquired only on the issue who has joined earlier, Lordship. So the inquiry was conducted behind my back. After that, based on the inquiry report, I was demoted and petitioner was promoted to the post of headmistress, Lordship. My Lordship.
You were demoted and petitioner was.
Yes, I was given to the post of assistant teacher and she was promoted to the post of.
The other person.
Yes, Lordship.
The petitioner, sorry.
The private aspirant, Lordship.
Yes.
I was headmistress. Based on the joining report saying that she had joined earlier to me, I had joined in the year 2001. Based on that, Lordship, I was demoted to the post of assistant teacher and my friend's client was promoted to the post of head teacher, Lordship. Now, Lordship, I'll just now during that period, Lordship, there was no managing committee. There was no managing committee. The power was exercised by the state respondent, that is the sub-divisional school education officers. My contention before this honorable court is that neither in the RTE rules nowhere prescribed that the government has the power. Why I am referring to rule Act of 1981, that is the Meghalaya Education Act, Lordship, prescribed that these are the aided school. Whatever action is to be done, it has to be done through the managing committee. Government is just an approving authority, Lordship. My lord, while sitting in the DB regarding that Marbanian case, my lord well aware regarding that the single bench has quashed that notification saying that the teachers cannot participate in the election. Division bench has already upheld with regard to the limited power of the government with the teachers of the school, Lordship, aided school. Now, I am not saying that this is not a departmental proceeding. I just realized that whatever action is to be done, the power lies with the managing committee. That is the access. Government is just an approving authority. And RTE rules, Lordship, neither in the RTE Act nor in the RTE rules, nowhere prescribe that government has the power to do any action against the employees. The RTE rules what? They set up the principles to set up just to improve the quality of the education. SSA and the RTE, Lordship, I'll just give one, what is the object of SSA and what is the object of, Lordship. And when did the SSA come and when did the RTE came into force, Lordship? I'll just, this is my lord, in the I put the flag, Lordship.
Just a moment. Mr. Bhattacharya, as far as those teachers are concerned, in a particular school, those who are under the SSA scheme, do they function under separate service rule?
Well, they'll be guided.
Vis-a-vis those who are not under the scheme.
Well, they are only guided. My instruction, my lord, they are guided by the RTE rules. Now, my lord, they are not guided by. I sought clarification from the department also whether they are guided by Meghalaya School Education Act. The answer is no, my lord. This is the answer which I got from them. Apart from that, my lord, any other rule, if it is silent on any other rule, my lord, then the 2012 rules will apply, my lord. Service
with
code.
regard to government school. Government school.
Other than that, the RT rules, my lord.
RT, that is why I am saying, Lordship, RT, the school, the petitioner is appointed in 2001. The RT rules came into implemented or came into force. In fact, the RT Act came into force on 1st of April 2010. My friend has relied some provisions of the RT rules as well as RT Act. That relates to standard of school, that relates to qualification, that relates to constitutional managing committee, that did not speak about that they can take any action. They can take like promotion or demotion of any teacher working in such school, Lordship. Then, Lordship, I'll just come to that inquiry report, Lordship. Inquiry report, in fact, I was not given inquiry report. That the in-pin order I have given, Lordship. That is at page 34, Lordship.
Inquiry report, page 34 is the order.
Yes, that is the order, but inquiry report was not supplied to me, Lordship. That was placed on record during the course of the hearing when the court, Lordship, posed a query with regard to the inquiry report, Lordship. Then my friend has placed on records. This is just content of more or less is the same, Lordship. That as per the inquiry report number so-and-so, dated so-and-so, submitted by R. Kumar Hazang, Block Mission Coordinator, SSA, and as per UDICE 2014, which is filled up by the headmistress herself, it is shown that Srimoti so-and-so, that is the private respondent, Lordship, is senior to Srimoti so-and-so, that is the petitioner herein. Srimoti Auleda Sheikh has joined in the year 2000 and Srimoti Shupia Khatun in the year 2001. Thus, based on their joining report and appointment letter, Srimoti Auleda Sheikh is hereby approved as the headmistress of Tilapara SSA so-and-so. Therefore, Srimoti Shupia Khatun is hereby directed to immediately hand over all the charges. The approved headmistress, Srimoti Auleda Sheikh. I was appointed in 2001 and she was appointed 2000. That time the school was not getting any sanction from the government, Lordship. So totally managed by the managing committee. After 15 years, so to say 16 years, Lordship. Based on the joining reports, I was given the assistant teacher and she was promoted. Here I have raised 3 issues, Lordship. Number 1, Lordship, that the authority which have passed the order does not have the jurisdiction. School is run and managed by the management. It has to be done by the management. That is why with regard to the jurisdiction power, Lordship, I was referring 1981.
Yes.
That in aided schools, the power to appoint, the power to dismiss, the power to promote is to be done by the managing committee. Government is just giving approval.
But in-pin order is this page 34?
Yes, page 34, Lordship. Now, second argument, Lordship.
Yes.
Lordship, after the 16 years, Lordship, even if there is a power, Lordship, still they cannot exercise. I have relied some judgment, Lordship, with regard to the delay claim of promotion and...
That is because of efflux of time.
Pardon?
Is that because of efflux of time?
Yes, Lordship. Delay and losses will come, Lordship.
Fine.
In my written argument, relevant para I have, in the earlier occasion, I have read out and I have given, Lordship. Now, Lordship, another pertinent point, Lordship, which I have raised before passing the in-pin order. neither any show cause notice nor any opportunity was given to me. In fact, I was not aware with regard to the inquiry also. Now, Lordship, here in my written submission, Lordship, page 15, Lordship, apart from the Meghalaya School Education Act, Lordship, there is a provisions for service rules for aided school, Lordship. Page 15 of my written submission. This is a complete court, Lordship. This court relates to not only schools, Lordship, even all the aided schools and colleges in the state of Meghalaya, Lordship.
Yes.
Page 15 is the service rule for employees of government aided schools.
Yes.
It has been copied from 170, page 170 of this book, Lordship.
Okay.
This is apart from Meghalaya School Education, Lordship Act.
Yes.
Lordship will kindly see appointment and dismissal.
Yes.
The managing committee of the school is the authority to appoint persons in connection with the affairs of the school, and as such it is the authority to dismiss or remove such persons. Here it is not a case of removal or dismissal. Why I am referring with regard to the powers. Now, Lordship, conduct and discipline rules. 5, Lordship.
Yes.
Any of the following penalties may be imposed on an employee of an aided school by the managing committee for good and sufficient reasons. Dismissal or removal, reduction in rank. Here I can say my rank has been reduced, Lordship, for no any reasons. Since I was headmistress, from headmistress I was put down to the post of assistant teacher. So I can say my rank has been reduced. Recovery, stop and censure. Now, next page, Lordship, that none of these penalties shall be imposed on an employee on aided school until he has given a reasonable opportunity of showing cause against the action proposed to be taken
Yes.
to him. Here, what I am trying to impress upon before your Lordship, apart from Meghalaya Act of Education Act 1981, there is a separate rules prescribed for the aided schools. So here also says, if any punishment is to be taken by the managing committee, they have given a show cause notice. Without giving any proper opportunity of hearing, they cannot do anything. Here also says the power, ultimate power lies with the managing committee. One thing, Lordship, I was appointed by the managing committee. How can they exercise the power? Power, obviously, there is no rules where the appointing authority is X and the dismissal, removing authority or the reduction in rank, the authority will be Y. The same authority will exercise the same power of reduction, promotion or removal. Now here, in support of that, with regard to the power, Lordship, I have relied some judgment, Lordship.
Yes, what are those judgment?
Lordship, judgment in my written submission, Lordship, page 3.
Page 3.
Page 3, Lordship.
Yes.
First judgment Lordship 2013, relevant para Lordship 61, 62 and 7 and 9. Then second judgment Lordship 2011 to Northeast Journal 290, relevant para 3 and 4 Lordship. Then 2019 SCC Online Meghalaya 122, relevant para Lordship 7 and 10 Lordship. Now here Lordship below.
Yes. What does this judgment say?
This judgment say with regard to the applicability Lordship, that aided school Lordship, aided school. Page 8 Lordship.
This is the one first.
This is the citation Lordship, and if I read the head note Lordship, termination of service, Education Meghalaya Education Act, section 9(2), applicability of in case of aided school.
Yes.
Here only with, I just want to show the power. Power lies with the managing committee. Now, next judgment Lordship.
Page
will be Lordship 10 Lordship.
Yes.
Para will be 3 and 4 Lordship, 3 and 4.
Yes. What does it say?
Here also says, from the affidavit in opposition of the state respondent, it is obvious that following the constitution of new managing committee, the petitioner has not only been replaced as the secretary of the managing committee but also deprived of his salary, so and so. So now Lordship, yes Lordship, the affidavit in opposition also reveals that this action has been taken by the respondent on the grounds that the petitioner has never attended his duty and has never engaged some other persons on contract basis to teach the school children. It is contended by the Mr. E.C. Suizer, learned counsel for the petitioner, that the impugned action of the respondent is not only arbitrary but has contravened the provision of section 9(2) of the Meghalaya Education Act and proviso 1 to rule 4 of the rules regarding the conduct and discipline of the employees of aided educational institution. At this stage, it may be useful to reproduce the provisions of 9(2) of the Meghalaya Education Act 1981 herein under. Here Lordship, 9(2) power lies and subject to any rule that may be in this behalf, no employee or recognized private school shall be dismissed, revoked or reduced in rank, nor shall his service be otherwise terminated except with the prior approval of the competent authority. Government is the competent authority to give approve. The ultimate action has to be taken by the managing committee. Now I refer to Rule 5 of the service rules, which I have relied Lordship, page 170 of the Meghalaya Education Act Lordship. They have copied here Lordship.
Yes.
This is the relevant. Then another judgment Lordship, page 13. My friend was the GA for the state in that case. 7 and 10.
Yes.
7, Mr. KP Bhatta's learned GA for the respondents. Number 1, 2, 3 submits that it is a precondition that as per the rules, before a teacher is terminated or released from service, the approval of the competent authority is to be obtained, which is the case perhaps has not been adhered to. He further submits that in regards the respondent number so and so from the as regard to the manner in which the proceedings have been conducted and whether due process has been adopted, but the query was never replied to by the respondent number 3. Then 9, the basic contention on the writ petition is that the petitioner has been terminated from service in violation of the principle of natural justice and the requirement as contained under 9 of the Meghalaya Education Act. It is also noted that the course of submission that the Learned Counsel for the respondent number 4 also does not refute this contention that the process adopted was not in accordance with law, though there was an allegation of negligence, insubordination and misconduct against the petitioner. In view of the stated submission of the Learned Counsel for the counsels and the cessation of the case, the impugn order of termination is unsustainable in the circumstances aforesaid. As such, the impugn order that is also being illegal and violation of the principle of natural justice and the provisions of the Meghalaya is hereby set aside and quashed, and the respondent number 4 directed to take back the petition in service. This is with regard just showing the power, Lordship. The power lies with the management. Now, to judgment, Lordship, I have relied on the same issue, that is judgment rendered by the Delhi High Court, Lordship. Our Education Act, Lordship, 1981 is a replica of Meghalaya Delhi Education Act, Lordship. Is the copied from their Lordship. The page 6, Lordship. I have cited the relevant para, Lordship, with regard to the same issue, Lordship.
Page 6.
Page 6, Lordship.
Yes. So these are the two cases.
Pardon, Lordship?
These two?
Yes, these two, Lordship.
1996 SC Online?
Yes, Lordship. I have given in the compilation of this record.
Yes. Then?
Now, Lordship, now the law says,
yes, yes, what does it say?
Law says if a institute provides for a thing to be done in a particular manner, then it has to be done in that manner alone and in no other manner.
Just a moment, Mr. Shi.
Pardon,
here you have noted this number 2 is 1992 SSC Online, Delhi.
Delhi.
182.
Yes, Lordship.
But you have not indicated the paragraph.
Sorry, Lordship. Lordship, there is no paragraphing in this.
Okay.
There is no paragraphing, Lordship, because
page.
It starts from page will be 25 and
this this page is 182.
180, Lordship.
182 to which page?
In my compilation, Lordship. In my compilation, their page will be, Lordship.
No, you have. Have you annexed this copy?
Yes, Lordship. Yes.
Page
number will be 26, Lordship.
6. Okay.
I think I have highlighted, Lordship.
You have highlighted.
Highlighted, yes, Lordship.
That is page 26, 27.
26, 27, and some part also 27. The most relevant is 26 and 27. I have highlighted, Lordship.
Yes, this way. Please go on.
Now, Lordship, the power lies with the management. Government is an authority. Even the institute as well as the rule says that the sole authority is the management. Now, with regard to that issue, Lordship, I am relying on judgment, Lordship, that when the institute provides that a particular act is to be done in a particular manner it has to be done in that manner only. They cannot go to adopt the other option, Lordship. They cannot take the other option, Lordship. That will be SCC 2021 6 SCC.
Yes.
707.
Yes.
Para number 14, Lordship. Para number 14, the page will be, Lordship, 37 in my compilation.
Yes.
Page 37 in my compilation, Lordship. This court has time and again emphasized that if institute provides for a thing to be done in a particular manner, then it has to be done in that manner alone and in no other manner. Among others, in a matter relating to the presentation of an election petition as per the procedure prescribed under the Patna High Court rules, this court had an occasion to consider the rules to find out as to what would be the valid presentation of an election petition. In Chandra Kishore Jha versus Mahavir Prasad, and in the course of the consideration observed as herein under the relevant para, it is well settled institute principle that if institute provides for a thing to be done in a particular manner, then it has to be done in that manner and no other manner. Therefore, if the institute provides, if the salutary principle is kept in perspective in the instant case, though the authorized officer is vested with the sufficient power, such power is circumscribed by the procedure laid down under the institute. As such, the power is to be exercised in that manner alone, failing which it would fall of the requirement of complying with due process under law. We have found fault with the authorized officer and declared the action had only insofar was not following the legal requirement before and after freezing the account. Here also, Lordship, even if they have the power, Lordship, Lordship, in fact, neither in the Act, nor in the rules, nor in the RTE Act or the RTA rules provides that they have the power. Even if they have the power also, they have to follow the procedure laid down in that rules or the Act. Here I am saying that the power lies with managing committee as per the Act, as per the rules. That is why they cannot do a thing which is not authorized by law, because the law never contemplates that the government can do the thing in that manner. The law contemplates otherwise. Now, Lordship, in the counter affidavit, Lordship, apart from the reason, they have taken some supplementary reasons. They try to supplement the reasons, which was not the part in the in-pin order, Lordship. The in-pin order says that she was senior, I was junior. She joined in the year 2000 and I joined in the year 2001. That is why the in-pin order was passed. And in the counter affidavit, they try to justify the reason by supplementing the reason, Lordship. The same judgment, Lordship, with regard to that issue, Lordship. Same judgment, Lordship.
Yes.
2021 6 SCC 707. Relevant para with regard to that issue will be 12, Lordship.
Yes.
12. In my compilation, page will be 36, Lordship.
Yes.
The action sought to be sustained should be with reference to the content of the in-pin order communication, and the same cannot be justified by improving the same through the contention raised in the objection statement or affidavit filed before the court. This has been succinctly laid down by this court. This is a full bench judgment, five benches, Lordship. Mahendra Singh Gill versus Chief Election Commissioner as follows. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to the court on account of a challenge, get validated by additional grounds later brought out. We may here draw attention to the observations of both so-and-so that public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanation subsequently given by the officer making the order of what he meant or what was in his mind or what he intended to. Public order must be made by public authorities are made to have public effect and are intended to effect the things and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself.
Yes. It's the same principle.
Yes, Lordship. Now, Lordship, with regard to belated claim, delay and lasses, I relied two judgment, Lordship. That is at 2010. 12 SCC 471.
Where is it in here?
In my compilation, Lordship, page 40 is the
40.
judgment.
40.
40, Lordship. Here I have relied few paras, Lordship.
Yes. Yes.
From para 18, Lordship.
Yes.
In my, that page will be 49 in my compilation, Lordship. Here, although he has not approached, she has not approached before this honorable court to challenge the promotion, to challenge that order, my post of headmistress, but he has filed application before the authority. The question of entertaining the petition disputing the long-standing seniority filed at a belated state is no more res intrigues. A constitution bench of this court in so-and-so versus State of Maharashtra considered the effect of delay in challenging the promotion and seniority list and held that any claim for seniority at a belated state should be rejected inasmuch as it seeks to disturb the vested rights of other person regarding the seniority, rank and promotion which have accrued to them during the intervening period. A party should approach the court just after accrual of the cause of complaint. While deciding the said case, this court placed reliance upon its earlier judgment particularly in Tilaksan, Motisan versus SB Munshi, wherein it has been observed that the principle on which the court proceeds in refusing relief to the petitioner on the ground of delay or laches is that the rights which have been accrued to others by reasons of delay in filing the writ petition should not be allowed to be disturbed unless there is reasonable explanation for delay. The court further observed as under the party claiming fundamental rights must move the court before other rights came into existence. The actions of court cannot harm innocent parties if their rights emerge by reasons of delay on the part of the person moving the court. This court in para 19, this court in Ramachandra Shankar Diodhar case also placed reliance upon its earlier judgment of the Constitution bench in Rabindranath Bose versus Union of India, wherein it has been observed as under. It would be unjust to deprive the respondents of the rights which have been accrued to them. Each person ought to be entitled to sit back and consider this appointment and promotion effected a long time ago would not be set aside after a lapse of a number of years. Paragraph 21, Lordship.
Yes.
The issue of challenging the seniority list, which continued to be in existence for a long time, was again considered by this court in so-and-so. The court has held as under. A government servant who is appointed to any post ordinarily should be, least after a period of 3 or 4 years of his appointment, be allowed to attend to the duties attached to his post peacefully and without any sense of insecurity. Satisfactory service conditions postulates that there should be no sense of uncertainty among the government servants created by writ petitions filed after several years, as in the case. It is essential that anyone who feels aggrieved by the seniority assigned to him should approach the court as early as possible, as otherwise, in addition to the creation of a sense of insecurity in the minds of the government servant, there should also be administrative complications and difficulties. In these circumstances, we consider that the High Court was wrong in rejecting the preliminary objection raised on behalf of the respondent to the writ petition on the ground of laches. Para 22, Lordship. While deciding K.R. Mughal case, this court placed reliance upon its earlier judgment in so-and-so, wherein it has been observed as under. Although security of service cannot be used as a shield against administrative action for lapses of a public servant, by and large, one of the essential requirements of contentment and efficiency in public service is a feeling of security. It is difficult, no doubt, to such security in all its varied aspects. It should be at least be possible to ensure that matters like one's position in the seniority list after having been settled for once should not be liable to be reopened after the lapse of many years at a instance of a party who was during the intervening period chosen to keep quiet. Raking up old matters like seniority after a long time is likely to result in administrative complications and difficulties. Same thing happened, Lordship, here. After a long time, the state respondent had reopened this settled issue, Lordship. It would therefore appear to be the interest of smoothness and efficiency of service, and that matter should be given a quietus after lapse of some time. Then para 23 and 25, Lordship. In B.S. Bajwa versus State of Punjab, this court, while deciding the similar issue, reiterated the same view, observing as under. It is well settled that in service matter, the question of seniority should not be reopened in such situations after the lapse of a reasonable period, because that results in disturbing the settled position which is not justiciable. There was inordinate delay in the present case for making such grievances. This alone was sufficient to decline interference under. Here, the persons who were denied promotions came to the court since there was a delay. In fact, law provides for them. Here, law does not provide.
Yes.
Para 25. In PS so this court observed that case where the petition was filed
So,
after.
see, all this, you see, same principle has been
Same
reiterated.
principle. Here, for same principles. Now, Lordship, what my friend has stated in his written submission, he says that the SSA I'll just refer his written submission, Lordship.
Yes.
His page 4, Lordship.
Page 4.
Page 4. Here there is no dispute with regard to the applicability of the RT rules, Lordship. If you read, Lordship, definition of school in the Meghalaya Education Act as well as in the RTE Act, they defines the RTE Act applicable to all the schools, government, aided, even unaided also, even minority schools also, that RTE Act applicable. And Meghalaya School Education Act, if my lord read the definition clause, there also says pre-primary, primary, upper primary, middle and higher secondary. So he has relied further section 18 of the Right to Children Free and Compulsory Acts deals with the certificate of recognition of schools.
You're reading page 4.
Page 4.
Which part?
As far as the contention as to whether the said Lapara school falls under the grant in aid school or SSA schools.
Yes.
It is clarified that the same falls under the SSA school, as is also evident from the array of parties in the said petitions. Now, Lordship, my friend, the state respondent has taken grant in aid and SSA are two different things. Grant in aid means any lump sum salary received by the school through any means, whether it is a state fund or is a central fund or any other funds. The main is aided. So he mean to say that so the confusion created by the petitioner is baseless. I have created the confusion. No. My case is that it is an SSA school receiving aid from the SSA funds. In fact, central government is giving to the state and the state is disbursing to the, it is not through the state, through the central government. I am working under the authority, managing committee and the government. So SSA and grant in aid are not different. SSA receiving aid through the SSA, grant in aid school receiving aid from the SSA fund. Now he has referred section 18 of the Act deals with the certificate of recognition of school. Now that speak about opening of a new schools. In fact, the school was opened in 2000 and appointed in 2001, Lordship. And 19 of the Act deals with the norms and standards for school. This is also talks about what should be the standard of the school. If any persons, so to say, if I want to start a school, on my own, what would be the standard? What would be the norms that specified? Section 21 of the Act deals with the managing committee, school managing committee. Why there is a school managing committee? Section 23 of the Act deals with the qualification. That is why the NCT, the central government, in exercise of power granted under Section 23 of the Education, the Right to Education Act, Lordship, they prescribe the qualification, Lordship. They prescribe the qualifications.
Yes.
Now, next subpara, Lordship, so the rule 11 of the Meghalaya Right to Children Free and Compulsory rules the government frame, although the act was passed in 2009, came into force 1st of April 2010. I have given in that short note, Lordship, there. Deals with the recognition of schools for the purpose of Section 18 of the Act, as well as 12 of the same speaks withdrawal of recognition. Rules 13 deals with the composition of the managing committee. Further, Rule 18 deals with the salary and allowances and conditions of service of teachers. Although it has mentioned this salary and allowances and condition of service of teachers, but in the RTE, in pursuance of the RTE Act, the government did not make any service rules, Lordship. Did not. Although they have made the qualification, Lordship,
Yes.
but not the service rules, Lordship. And Rule 20 deals with the grievances redressal mechanism for the teachers. That being so, the petitioner could have approached the appropriate authority for redressal of her grievances. Hence, in respectful submission, this instant writ petition is permissive, and on this ground, it may be rejected by this honorable court. Now, whatever my friend has relied,
Yes.
none of the sections or the rules says that yes, that sub-divisional school education officer or the district school education officers has the power to deal with the situation if any grievances is put up before them.
Yeah, Mr. Sheikh, I think we'll now it's 1:30. We'll continue.
My lord,
Second half.
my humble request, my lord, if it can be continued tomorrow, my lord. It may come on the supplementary, my lord.
Tomorrow I have problem with complete, but tomorrow is
Day after.
hearing might be on like
Yes, because we cannot delay this matter.
Delay, but
My
this,
lord,
this will be
I
the
don't want to delay either.
Or Mr. S. Sheikh, let us counsel for the petitioner. As submitted, as paid for by the parties, hearing to continue on the next date. This matter. Today is
My lord,
on 9th. Tomorrow is 8th, tomorrow is 9th.
my lord's indulgence, my lord, Friday, I think it will be, court will be free most of the time, my lord. I think Friday will have ample time, my lord.
I don't have any problem.
Friday good case.
Yes, my lord, only difficulty is, my lord, before court number 2, my lord, I am having
Hearing. Yeah, bro. We only have 9.
10, what he, my friend is saying, 10.
10th.
Okay.
We can have it on 9th.
9th, my lord. Only difficulty, my lord, that my friend can continue. I might be having a lot of analogous matters, my lord, before court number 2.
We'll see. We can.
My lord.
We will always suggest.
My lord.
So 9. This is matter on 9.
Yes. Obliged, my lord.
Item number 7.
How many more items we have today?
Lordship, I'm praying for 2 weeks competition, Lordship.
This is also an old matter. On payment by petitioner, this is matter after. You are there in this case, all of you? 2 weeks.
Obliged, Lord.
Item number 8.
Lordship, similar prayer for you, Lordship. Similar prayer for you, Lordship.
Item number 8.
Payment by the appellant, this is matter after 2 weeks.
Item number 11.
Why you're not prepared to take up in the second half?
Lordship, I have it up to a week's time.
A week's time, Your Lordship.
On payment with parties, this is matter after 2 weeks.
Item number 13.
Yes,
Lordship, this matter, actually, my lord, the records would be very pertinent, my lord, before the hearing is taken up. Because there are issues, my lord, with regard to call records.
That
Question of that.
Yes, Lordship. Yes, Lordship.
Clear PS case, Lordship.
The observations was with regard to call records. So, if my lord be pleased enough to call the records.
What is the case proceeding?
Yes,
Yes, Lordship. The trial is going on.
If the trial is going
trial
on,
has not started, my lord. It is still at the stage of CC, my lord.
stage of CC.
Yes, my lord.
Stage of CC.
Yes.
Stage of CC.
And what is the,
Yes, Lordship.
What was the impugned order pass?
We had filed the application under 227, my lord. That was rejected, my lord. In fact, with regard to.
So it means that charges have been framed against you.
Not yet, my lord.
But order is for framing of charge.
Lordship.
Since 227 has been dismissed or
Lordship.
rejected.
He filed application under 227 in the trial court. It was rejected, and they have come here also.
But what is
against that order?
What is
Against that order.
There's no stay order.
No.
There's no stay.
What is the order of the latest order?
Actually, my lord, in respect to my accused, my lord, there is no.
How many accused?
There are
many.
Almost 25, my lord. 25 accused.
20?
25, my lord.
This is
This is the case wherein that social worker was attacked.
Assaulted,
in
my lord.
Jaita Hills, East Jaita Hills.
In calling for a court order, please.
I think
only if you have to rely on portions of the record, you get a copy of it.
Yes. Then, my lord, if I may pray, if not the entire case record, only if the call details record may kindly be called, my lord, because the finding of the trial, the special judge.
That would be available in a copy of your.
Entire thing is not there, my lord. It's voluminous, almost 1,000 pages, my lord.
You have it with
only the observations, only
you
the.
have it with you.
No, only the extract of the call records. So we have it. We have enclosed, my lord, here.
Then
for the satisfaction of this honorable court, if my lord requires that.
If the prosecution does not object to the authenticity of the.
Then I have no problem, my lord.
You look at it. You see. This court would not.
Because as per the whatever has been extracted, my lord, which is given to us.
They will also have a copy of the
lordship.
If my lord, charge sheet which he has enclosed, lordship, is incomplete,
lordship. Because
you see, it's incomplete.
It's incomplete.
Incomplete as of the copy that was given to him, or incomplete.
No,
as far as extract is concerned.
The copy which he enclosed is incomplete.
Okay. But he has a complete.
Yes, lordship. Lordship. My lord.
Because you're saying it's voluminous.
Yes, my lord. That is the only difficulty, my lord.
And what is there? What is it? You see, irrelevant materials need not be considered.
Lordship.
Yes.
If he's relying only on some portion, for example, the
CDR,
CDR, then we'll confine to that.
Lordship.
I don't think it would be your case. If at all this court find that he has produced incomplete records, then it will go against him only.
Because in this petition, Lordship, he has enclosed only the CDR of the other accused persons. In this case, there is no CDR in respect of this instant accused
If you
person.
have it with you, then you produce it.
That is why what I was praying, just my lord, for the interest of all the parties, only in respect to my lord, the CDR may kindly be called for. Entire record may not be necessary, my lord.
That
Only
would be, I
CDR.
think that would be incumbent upon them to do.
Lordship.
You produce copies of only copy.
Only copies, my lord.
Lordship may pass the order.
Yes,
May
of course.
pass the order. I'll communicate it to DIO, Lordship. Because verbally like this, they will not cooperate, Lordship. If the order is there, then they'll
See, Mr.
will
Kami,
communicate.
I've made it clear time and again that you are a responsible officer of the court. You are,
Yes,
in fact, you are a legal officer of the state.
Yes.
If even by verbal request, if your request is not heeded by the IO or others, then it speaks volumes about your so-called power.
Lordship, I have contacted
You
the
have-
IO. He
you
said
have
we don't have the copy. We have submitted it to the court. Copy. So
Whatever, you see, even if it is submitted to the court,
yes,
a copy is always there. Copy is always there.
it's there, but they are not
Additional copy,
they're not,
extra copy, whatever is there.
additional copy or duplicate copy.
Whatever.
I told the IO like that you must be having the duplicate with
It's not a
you.
question of telling the EU. It is question of you directing the IO.
Absolutely.
If he doesn't comply, you write to the concerned authority to take steps.
Yes.
That is for you and your client. How you manage. But please do it. When a matter came up for hearing, the Leonard additional PP, Mr. H. Karmi, has submitted that the complete record have not been submitted by the petitioner for this court to produce the same. In particular, the CDR and call record details, in the bracket CDR, of the communication made between the petitioner has not been produced before this court. The legal counsel for the petitioner would submit that the same is contained in the complete final report filed by the IO. However, since the contents is voluminous, it is submitted that only the relevant portion may be allowed to be produced before this court. The Leonard additional PP has submitted that he may be allowed to produce such record, copies of such record on the next date fix. As paper, how long?
2 weeks, Lord.
As paper, the same is allowed. Less is matter up to 2 weeks. Sure.